So this is part 5 of my read-through of the documents for the civil case between the Rodni and Robertson families and Ryan Upchurch. Now, before I push on, I am going to say I had some reservations about continuing, and I'll say why. I was just looking on YouTube and CCTV has put a video up, and in this video she went to visit Kiely's memorial, and sometime within the past week someone has gone in and destroyed Kiely's memorial, like vandalised, broken things up. So yeah, literally destroyed the memorial. And it could just be that, you know, we're heading up towards the 2-year anniversary and maybe that's a trigger. But I also am concerned that this has occurred when I've started looking at this civil case. It may be totally unconnected, and I hope that it's unconnected. I really hope that no one has listened to this civil case and out of some misguided loyalty towards Ryan has gone and destroyed Kiely's memorial, because I'm pretty sure that even Ryan would condemn something like that. I know he's not necessarily said the right things at times, but he would never condone someone doing such a thing. Of course, the other possibility that I have considered is that it has nothing to do with this, but more to do with Mrs. G posting that she was once again in Truckee and planning on visiting Kiely's memorial. And we know that there's a cohort of friends of a certain YouTuber who is a Truckee local who have a intense dislike of Mrs. G, and perhaps one of those friends decided to upset Mrs. G by doing this. I hope that's not the case also, but I cannot fathom why anybody would go and destroy a memorial for a deceased child. It's utterly, utterly disgraceful. I'm not going to continue talking about that because this is not what this video is about, and I think that CCTV has said it pretty succinctly in her video. Anyway, let's jump in and continue looking at this document. Part 6. On October 13th, 2022, the results of Kiely Rodni's autopsy report are widely circulated. No foul play is suspected. The manner of death is accidental. The investigation is noted as closed accident. I would dearly love to comment on this, but you all know what I'm thinking right now. Paragraph 104. Plaintiff incorporates all above paragraphs. Let's look at Ryan's response. I think we know what it is. So we have the standard response from Ryan. Mr. Upchurch is without knowledge or information sufficient to form a belief as to the allegations contained in paragraph 6 of the first amended complaint, which are therefore denied. And he repeats that for 104. For 105. And 104 is the standard. Mr. Upchurch incorporates his responses contained in the preceding paragraphs. So 105, which we know that already Upchurch has said insufficient knowledge denied. So on October 13th, news outlets began to report the results of the coroner's final report of investigation into the tragic death of Kiely Rodni. 106. In relevant part, the coroner's report concluded that the manner of death was accident. So since we can see here that the response is consistent for 106, 107, 108 and 109, in that he says that he is without knowledge or information and therefore it is denied. We will carry on and read through 107, 108 and 109. I guess before I do push on with these, I probably should mention or acknowledge that because this is a legal document, then I guess they have to go with official documents that were put out with regards to the case. So even if they don't believe that it was an accident and that Kiely drowned, I guess because it's a legal document they probably have to take this route. I'm not sure. I'm certainly finding this a hard pill to swallow, and I realise that there will definitely be people listening who are also struggling with seeing this in a document from Kiely's family. But let's carry on. 107, the cause of death was noted as drowning. 108, a narrative report by Sergeant Jason Clinkenbeard noted as follows. I have recently reviewed the pathologist's final report of autopsy, which listed the cause of death in this case as drowning. There were no other significant contributing conditions listed. I conferred with Detective Sonnier, and he told me there was no indication of foul play regarding the criminal investigation into the death of Kiely. The manner of death in this case has been determined to be accidental. Case disposition closed, accident. Just giving people a moment to breathe. Okay. 109. In relevant part, the report identifies the decedent as Kiely May Rodni. Paragraph 110. The report also mentions plaintiff Daniel Rodni in a section titled Next of Kin. And the standard response, Mr. Upchurch is without knowledge or information, therefore denied. Paragraph 111. Mainstream news outlets essentially stopped reporting on the Kiely Rodni case after the autopsy report was released in October 2022. So the response here starts with without knowledge, insufficient information, yada yada, therefore denied. But he does add in one sentence, much speculation and discussion from others about Ms. Rodni's continued online, which is true. Upchurch continued to post about the Kiely Rodni case as late as December 22nd, 2022, when he uploaded a video titled Kiely Rodni Only Logic, Part 1. Mr. Upchurch admits that he posted a video on the 22nd of December with the stated title. And before we look at 113, it says here that Mr. Upchurch admits the allegations contained in paragraph 113. In this video, Upchurch stated, let's be honest with ourselves. At this point in the video, there is nothing to lead me to believe that this person is real. The Kiely Rodni person. There is nothing that shows me she is real yet. In this video, Upchurch also reiterated his theory that Kiely Rodni was a girl named Kelly Ross. And for this we get the same response, Mr. Upchurch admits allegations. I will look at 115 and 116 together because we already know the response for 115, and that will be that Ryan doesn't have sufficient knowledge, therefore denies. So it seems that he doesn't look at his view count when it comes to videos. So 115, this video has 138,388 views at the time of this filing. So should you wish to check it out, the link for this video is on the bottom of the page there, so you can copy that and have a look. Let's go on with 116. In a comment to this video, a YouTuber named Steve's Random Adventures commented, "So basically you want everybody to believe you, even though you have zero proof and you're claiming this girl doesn't even exist. Yet you're on here saying that you're not going to believe anybody else because they don't have proof. Streaming revenue must be going down." So the response to 116 was, Mr. Upchurch admits the allegations contained in the complaint. Paragraph 17. Upchurch replied to this comment, "No, it's actually at an all-time high, and that's why I'm making an insane amount of money, which is why I'm flopping my on the table and trying to fight corruption. Because I'm a good guy and I'm rich. Fighting evil that is rich, because that's what I do." And the response, Mr. Upchurch admits the allegations, but denies that this comment is related to the case at bar. Mr. Upchurch was referring to his music streaming revenue, not revenue from YouTube views. Paragraph 118. A photo of this exchange is below. So that's the screenshot of what they just quoted. And the response, of course, Mr. Upchurch admits the allegations. I'm going to do 119 and 120 together because I'm pretty certain we know what the response for them will be. So 119, this lawsuit was originally filed on July 28th, 2023. 120, various YouTube channels discussed the filing of the lawsuit and the allegations it contains. So 119, Mr. Upchurch admits allegations based on the information he has now. Mr. Upchurch denies he was aware on July 28, 2023 that this lawsuit had been filed. And 120, Mr. Upchurch admits the allegations contained in the first amended complaint. So I've just done a brief sidestep. I went back into PACER and went looking for documentation to show when Ryan was served. And while there was a summons which was dated the 28th, as mentioned in these documents, we can see this document here was dated the 1st of August. And what is relevant here is that it is a waiver document, meaning that at the date that this document was created, Upchurch was yet to have been served with the suit that we're looking at. So I'll just quickly go through this so we can look at what it says. So notice of a lawsuit and request to waive service of a summons to Ryan Upchurch through his attorney. And it continues, why are you getting this? A lawsuit has been filed against you or the entity you represent in this court under the number shown above. A copy of the complaint is attached. This is not a summons or an official notice from the court. It is a request that, to avoid expenses, you waive formal service of a summons by signing and returning the enclosed waiver. To avoid these expenses, you must return the signed waiver within 30 days from the date shown below, which is the date this notice was sent. 2 copies of the waiver form are enclosed, along with a stamped self-addressed envelope or other prepaid means for returning one copy. You may keep the other copy. What happens next? If you return the signed waiver, I will file it with the court. The action will then proceed as if you had been served on the date the waiver is filed. But no summons will be served on you, and you will have 60 days from the date of this notice is sent to answer the complaint, or 90 days if this notice is sent to you outside any judicial district of the United States. If you do not return the signed waiver within the time indicated, I will arrange to have the summons and complaint served on you, and I will ask the court to require you or the entity you represent to pay the expenses of making service. Please read the enclosed statement about the duty to avoid unnecessary expenses. I certify that this request is being sent to you on the date below. So it was sent to his lawyer on the 1st of August 2023. So it is correct that Upchurch probably did not have knowledge of the case on the 28th of July. So we will move on to paragraphs 120, 121 and 122, and we'll just look at the responses here first, which is Mr. Upchurch admits the allegations contained in these paragraphs. So 120 is various YouTube channels discuss the filing of the lawsuit and the allegations it contains. Paragraph 121, on July 30, 2023, Upchurch posted a message to his community on YouTube. Paragraph 122, the message read, "I'm not at all sorry for anything I've ever said on the internet, at all whatsoever, and never will be, period. That's all I wanted to say, lol." And that's the screenshot and the link down below. Now here's where we start to get into the nitty-gritty of it, and I suppose logically this would have been a good spot to stop the video, but we're only 17 minutes in, so I'm going to push on for a little bit longer. So causes of action. 1. Defamation. 123. Plaintiffs incorporate all above paragraphs, and of course the defence response will be the same. So 124. In addition to the statements described above, plaintiffs submit various video files, Exhibit A, of various defamatory statements made by Upchurch in his video broadcasts. These files will be manually filed with the clerk. So in terms of paragraph 124, Upchurch admits plaintiffs filed various video files with the court, but denies they include defamatory statements by Mr. Upchurch. Paragraph 125. Upchurch published several statements of and concerning both David Robertson and Daniel Rodni through the broadcast of his YouTube videos relating to the Kiely Rodni case. The response. Paragraph 125 contains a legal conclusion to which no answer is required. To the extent an answer is required, Mr. Upchurch admits the allegation contained in paragraph 125 of the complaint. I'm not sure why it's quite worded that way. It looks like he's basically saying that he did publish several statements relating to David and Daniel, but I'm not sure why he didn't use the same formatting as he previously did. Okay, so paragraph 126. Upchurch's false claims that Kiely Rodni was not real, David Robertson was not real, and Daniel Rodni were not real, defamed the plaintiffs. Okay, so it seems like the standard line now is that the that paragraph contains a legal conclusion to which no answer is required. To the event an answer is required, Mr. Upchurch denies the allegations contained in paragraph 126. So he is saying that he did not defame the plaintiffs. Paragraph 127. Upchurch's false claims that Kiely Rodni was a bullshit person and that her disappearance was a scam to raise money on GoFundMe defamed the plaintiffs. The response being, it's a legal conclusion, no answer is required. To the extent an answer is required, Mr. Upchurch denies the allegation contained in the complaint. Paragraph 128. Upchurch's false claims that plaintiffs were involved in a GoFundMe scam imputed criminal activity to plaintiffs, defaming them. So you've got all the standard legal stuff, and then to the extent an answer is required, Mr. Upchurch denies the allegation. So because it wasn't broken up at all, that means that he's denying the whole thing, that he had made claims that they were involved in the scam, and he's also denying that there was any inference of them being involved in criminal activity and that he had defamed them. Paragraph 129. Upchurch's false claims that plaintiffs were in fact relatives of a person named Kiely Ross, implying the plaintiffs were actors pretending to be someone other than they were, defamed the plaintiffs, which once again is denied in full by Upchurch. Paragraph 130. Upchurch's false claims that plaintiffs were involved in a scheme to catfish, fake a death, defamed plaintiffs. And the response, to the extent an answer is required, Mr. Upchurch denies the allegation contained in the complaint. Paragraph 131. As a result of these statements, plaintiffs suffered reputational injury, financial losses, and emotional distress. So the response for paragraph 131 is he denies allegations, and that is the same for 132. So let's look at 132. 132. As a result of Upchurch's false statements, plaintiffs suffered personal humiliation and mental anguish and suffering. So he said he denies that. So paragraph 133. Each plaintiff has received therapy for psychological injuries specifically attributable, as documented in the medical records, to the conduct of Ryan Upchurch. The response to this being that he is without sufficient knowledge and therefore denies that any of his conduct caused the plaintiff's damages. Paragraph 134. Upchurch made each of the above statements only after authorities had publicly identified Kiely Rodni and confirmed her identity. The response being Mr. Upchurch is without knowledge and therefore it is denied. Paragraph 135. Upchurch made each of the above statements only after Kiely Rodni's family had released a written statement confirming her death. So for 135, 136 and 137, the response is the same. Basically, he denies the allegations. So looking at 136, Upchurch thus made his false and defamatory publications with reckless disregard for the falsity of the statement. So that's one that he denied. And the following one is 137. At a minimum, Upchurch acted with negligence in failing to ascertain the truth of the false statements he published to his roughly 3 million YouTube subscribers, which also he denies. So that's the end of that particular section, which is a good place to stop. So I will once again continue with this tomorrow. Thanks for listening. Please subscribe if you're not already subscribed. Please hit the like button if you haven't done so. And also please leave a comment below with your thoughts.